Good afternoon and welcome to DQ, and we don't mean Dairy Queen, presented by Florida Appeals. I'm Shannon Macklin, an appellate lawyer and founder of the firm. Florida Appeals specializes in appeals and trial support throughout Florida. This is the second CLE that Florida Appeals has hosted. The first one is about preserving error for appellate review, and it's available for free on our website. This CLE will also be available there, and we plan to host future CLEs quarterly. So if you have any other topics you think would be helpful for us to cover, please let us know. I'm joined by three of our appellate lawyers. Robert Scavone Jr. will moderate today's presentation. Robert clerked at the United States Court of Appeals for the 11th Circuit for Judge Adalberto Jordan and at the 3rd District Court of Appeal for Judge Barbara Lagoa. Bill Palmer will begin with an analysis of initial motions to disqualify. Bill served on the 5th District Court of Appeal for 18 years and was chief judge of that court from 2007 to 2009. He and former 5th DCA Judge Earl Peterson provide our firm with over 30 years of appellate judicial experience. After Bill, Tom Skolko will address successive motions and appellate review. Tom served as a judge of compensation claims for 17 years before joining Florida Appeals in 2022. Tom is one of a handful of lawyers who is double board certified. He's board certified in both appellate practice and in workers' compensation. If you all have any questions, please put them in the chat and we'll get to as many of them as we can. If we run out of time, please feel free to email us directly at info@floridaappeals.com and we'd be happy to help. Thank you for joining us. We hope you enjoy the program. And now I'll turn it over to our moderator, Robert Scavone Jr.
Thank you very much, Shannon, and thank you for the introduction. Thanks, everyone, for tuning in for this CLE program. As Shannon mentioned, we have another CLE on our website, and we will have the link at the bottom of this particular CLE presentation. Before I bring Bill in, who's going to talk about the initial motion to disqualify, we want to talk about the fundamental underpinnings of why a litigant would have the right to try to recuse a judge. And we start with due process and the concept that all litigants deserve a neutral and impartial judge. And to have a partial judge or someone that would be biased against a litigant would violate that person's due process. One of the other things that judges have to keep in mind is that they have their own code of ethics and code of conduct, and it requires them to perform their duties in an unbiased and non-prejudicial way. So there is an obligation on the judge to make sure that he or she recuses when there is one of a number of different potential conflicts. And 3810 outlines the main one that we're going to talk about today, which is disqualification for prejudice. But Chapter 3800 includes other grounds or other reasons why a judge would have to recuse. If the judge is a party, obviously there has to be a recusal. If there is some sort of familial relationship, which we're going to get to a little bit later in the CLE, a judge should recuse. And obviously a judge can recuse on his or her own motion. She does not have to wait for someone to ask for the recusal. So, Bill, I want to bring you in and let you start off by telling us about the features of chapter or section 3810.
So to implement the due process concerns we're considering here, we have a statutory basis that sets forth some of those standards. So Section 3810 of the Florida statutes provides that in order to seek to disqualify a trial judge, you have to file an affidavit stating a fear that you will not receive a fair trial because the trial judge has shown prejudice or favor towards the other side. You have to specifically set forth the facts and the reasons why the party believes the trial judge is biased, and it has to be supported by a certification from counsel that the affidavit is made in good faith. It also provides that if such a motion is filed, the judge shall proceed no further until first resolving that motion for disqualification.
Thank you, Bill. And the substantive right obviously originates from the statute, but we also have Rule 2.330, which is the procedural mechanism by which a litigant would move to recuse or disqualify a judge. Bill, can you walk us through those the particular things that we've highlighted here?
Well, the rule first provides that it only applies to trial judges acting alone, so it doesn't apply to appellate judges generally. This indicates it does not apply to circuit judges sitting on a multi-member appellate panel, although that's greatly abrogated now. That it used to be that appeals from county court would go to a panel, an appellate panel, either of 1 or 3 judges in the circuit court, but now they go directly to the DCAs. And it provides that any party has standing to move to disqualify the trial judge. And we just have a case law here that if somebody cites the statute rather than the rule, that doesn't make the motion invalid.
Thank you, Bill. We're going to talk a lot today about legal sufficiency. Bill, can you explain how the parameters that are drawn out in 2.330 are important when it comes to having a legally sufficient motion?
Yes, you have to meet each of the requirements of the rule and the statute in order for it to be deemed legally sufficient, such that the judge has to treat it as a sufficient motion. It must be in writing. Now, keep in mind that you might make an oral motion during the course of a hearing or a trial, but it then needs to be reduced to writing to meet the requirements of the statute and the rule. It notes that you have to be specific in alleging the facts and the reasons for disqualification. So simply saying, I feel the judge is biased is not enough. You need to flush out the facts that go with that. You need to state the precise date the grounds for disqualification were discovered by either counsel or the party, whichever is earlier, since there are very strict time requirements for filing such a motion, which we'll be talking about in a little bit. And so the date has to be set forth to be able to determine whether it is in fact timely. It's got to be sworn to by signing the motion or an attached affidavit. As we mentioned before, the statute requires a sworn statement. It also has to include the date of any previously granted motions to disqualify, since, as we'll talk about a little later, the standard is totally different for a motion directed to a second judge as opposed to one directed to the first judge. And as I mentioned, it has to include a certification by counsel that the motion is made in good faith, as just another factor to make sure it is being made in good faith and not just for some tactical reasons. And it provides that the motion is in fact served on the trial judge, which makes sense. So he or she has an opportunity to see what's being alleged.
Bill, you noted the importance of the sworn affidavit that has to be part of the motion. What about attaching transcripts from a hearing or other documents that you want to use to support your claim that the judge is biased or prejudiced against you? Is that something that you've seen? Do you think it's a good idea?
I've seen transcripts attached. It helps to show exactly what the judge said, but since the allegations of fact must be taken as true in a first motion to disqualify, it isn't something that has to be provided to verify what the motion is saying and is otherwise sworn to under oath.
Got it. We're going to dig a little bit deeper now into the various grounds that a litigant may want to consider when seeking recusal. The first one that we touched on earlier, Judge, Bill, was the relationship to a party or counsel, that the judge has some sort of particular relationship. How does this generally come up?
Well, this is separate and apart from bringing one saying that the judge is biased or prejudiced, it sets up various degrees of relationship of the judge to the party or counsel, which basically per se indicates that they need to disqualify themselves without a separate showing of bias. And it indicates that if the judge or their spouse are within a third degree of relationship, and we've set forth here in a footnote what fits within a third degree of relationship, then that's a basis on which they need to recuse themselves. We note that there's a ground if there's more than a de minimis economic interest in the subject matter in controversy, if they've acted as a lawyer in the proceedings, if they have more than a de minimis interest that could be substantially affected by the proceedings, or if they're likely to be a witness in the proceedings. Those are all grounds that the statute sets up as a basis for disqualification of the judge.
Bill, how would you define, or how have the courts defined de minimis?
Well, I think it's generally fact specific. It's on a case-by-case basis. As an example, if a judge owns a few shares in a corporation, that corporation is a party in the litigation, but it's not the kind of litigation that would have any reasonable effect on the stock price. It's not a bet your corporation kind of a case. It's just something routine business, and there's no way that that this case is going to be affecting the stock price. That seems to me to be something that would be de minimis. There has been some law with regard to contributions made to a campaign of a judge, and it's generally it's been held that at a certain level, at one point it was $500. I don't know if that's gone up since then, but at one point the law was that a $500 judgment was per se de minimis and wasn't a basis on which to have a judge disqualified.
Mm-hmm. But what would happen in a situation where, for whatever reason, a judge didn't realize that one of these family members was party to the suit, and it comes out later, and no fault of the judge? What happens to that case?
Well, I think if one of the parties has just discovered that, they bring it to the attention of the judge. I think if the basis of the disqualification is the relationship to a party, you may not be under the same strict time restrictions as you would be when you're trying to disqualify somebody based on actual prejudice or bias. But it seems to me that at any point during the course of the case, if a party discovers that relationship, they bring it to the court's attention and can file a motion on that basis. They may not even have to file a motion, because if they bring it to the court's attention and the court didn't know about it, that's the kind of situation where a judge might on their own choose to disqualify themselves without requiring a motion.
Mm-hmm. And next, we're going to talk about the judge's knowledge. What are we talking about here, Bill?
General proposition being, if the judge has some knowledge of the case because of some other role or relationship other than what he or she learns sitting as a judge on that case, that's a basis on which to say that judge should be disqualified, because you don't want the judge using something extrajudicial in making their decision. So if the judge served as a lawyer on the case before, or was the lower court judge in the case before, or a lawyer with whom they practiced during the association was involved in the matter, that would be a basis on which the judge should be disqualified. And when you're dealing with what other members of that judge's law firm might have known, you're dealing with a proposition that basically, as a general rule, the knowledge of any one lawyer in a firm is deemed to be the lawyer of all the lawyers in the firm. And so the fact that it was a different lawyer working on the case would not generally provide a basis to not have to be disqualified.
So there's no ethical wall.
In general, with private law firms, that's the case. The rules regulating the Florida bar set up what's been deemed an ethical wall, where if somebody leaves from government service and goes into private practice, you can build that wall around them and keep them out of a case, and that keeps the law firm from being disqualified. But that really only applies in the context of a government lawyer going into private practice. It doesn't apply where you can wall off one private lawyer in the firm from other private lawyers and say they don't have knowledge. The rules regulating the Florida bar provide in 4-1.10 that when lawyers are associated in a firm, none of them may represent a client when any one of them would be prohibited from doing so. It recognizes an exception that it then lays out in Rule 4-1.11 to deal with government attorneys who are moving into private practice, but that makes it clear that it only applies in that context and not between two lawyers in a private firm.
Thank you for that, Bill. Thanks for the explanation. Now we're going to turn to the big one, the motion that we're going to be talking about for the rest of this CLE, and that is a motion to disqualify based on the judge's impartiality, bias, what have you. Bill, we want to first emphasize that timing is everything. The motion must be filed within a reasonable time, not to exceed 20 days. When might a motion filed in less than 20 days be unreasonable and therefore untimely?
I think the key in that regard would be to look at what happened during that time frame of less than 20 days. So if there's a hearing and the judge does something that some parties later saying is a basis for disqualification, but the judge gives some indication of which way he's going to rule, and they wait until the ruling comes out 10 days down the road, 15 days down the road, and when they don't like the ruling, they then file the motion. I think in that context, the court could determine that it was unreasonable to wait to see what the judge's ruling is going to be, albeit for less than 20 days. And in that scenario, I think they could determine that it was unreasonable, even that when it was less than 20 days.
And what about say situations where there are, a cumulative number of different events that took place over, more than 20 days? How does a litigant usually deal with that when they file the motion?
I think the key ingredient in that regard is you would have to set forth why the last event, which occurred within the 20 days, somehow tipped the balance in favor of showing that the judge was prejudiced or biased, that there are certain events that happened more than 20 days ago, but that on their own didn't create a reasonable fear of bias. But when you add the most recent event, which was within the 20 days, all of a sudden that's enough to tip the balance to where you now have a reasonable fear of bias. And under those circumstances, the court could say, yes, it's reasonable because it wasn't until that last act that you had a reasonable basis to think he or she was biased. But as a practical matter, that's always a risk, and therefore you're always better off to bring it sooner rather than later. You don't want to run the risk that the court doesn't buy your argument that it's the last act rather than an earlier act which tipped the balance.
Thanks for that, Bill. Now we want to talk a little bit about the court's order, how quickly the court must act. Bill, what are the parameters there?
Well, this is a rather unique situation. It's very rare that you have a situation that the trial court not ruling on the motion somehow impliedly rules on the motion. But in this context, it's very specifically provided that the trial court shall rule on the motion immediately and no later than 30 days after service. And if the motion is not denied within the 30 days, it's deemed granted. So unlike most situations where you can't read anything into the court not getting around to ruling for a while, here you have a very definitive timeline and a very definitive result, which is if it's not denied within that time frame, it's granted.
We'll turn now to sufficient grounds. We're also going to talk about insufficient grounds for a motion. Bill, highlight the most common sufficient grounds for filing a motion.
Well, you obviously set forth some action by the judge that you say shows personal bias or prejudice. It typically comes up in a context where the judge makes some reference to a party or to a counsel, not directly related to what the judge is observing, but maybe broader than that, more general than that. Using a derogatory term towards one of the parties that's uncalled for. And those are areas where it could very well be determined that that's a showing of bias, or it's at least creates a reasonable fear in the movement of bias. Comments on the credibility of a party, if it's not based on specific testimony that the judge has heard from the party. If he makes some general statement about, I'd never believe this person no matter what they say, that's some pretty good indication of bias or prejudice that would likely be sufficient grounds.
We also note here that comments that show disdain for a party or that denigrate a party are grounds for recusal. Bill, how do you distinguish that with the previous slide, where you have situations where the judge, like you said, might be making comments on something in the record? What's the line of demarcation for motion purposes?
I think the line of demarcation is if the statements are made and clearly made specifically based upon something the judge has properly heard during the course of a hearing or trial, then it's within their purview to comment on that, and that wouldn't show bias. But if it appears to be from something unrelated to what was presented in the hearing or the trial, that's when it crosses the line.
Got it. Bill, this is bringing up something that happened to me, and I'm sure it happens to a lot of prosecutors. I can remember times where a judge would, say to defense counsel, well, you should probably file a motion to suppress. Is that enough? We have this comment here that says, the judge should not suggest how a party should proceed. Is something like that, suggesting a party file a motion to dismiss or file a motion to suppress, will that trigger sufficient grounds?
I think it depends on how specific the directions are and maybe how generally accepted certain procedures are. And so in your context where the law is very clear that under this scenario, the thing to do is to file a motion to suppress, the court mentioning it isn't really directing the parties to do it, then that's probably fine. What the case law is trying to avoid are those situations where the judge is removing him or herself from their role as a neutral arbiter, and they're in essence becoming an advocate for one party or the other, which would demonstrate bias or prejudice.
Now we're going to look at a few insufficient grounds for a motion. The first bullet point.
Go ahead.
The first bullet point here: unflattering remarks or comments about legal argument or evidence. Is that distinguishable from, unflattering remarks from a few slides ago where the judge called the person, I think, an alimony queen?
I think the distinction goes back to whether this is somehow based upon specifically what they're observing. And so if they hear a legal argument and they say it's a specious legal argument or it's a ridiculous legal argument, that's probably fair comment based upon their role in evaluating the legal arguments. I think statements that talk about the credibility of a witness, but based specifically on what the judge has heard in their context, typically if in a context where the judge is the fact finder. So if you've got a jury trial where the judge isn't the one who's going to be judging the credibility of the witness, that's for the jury to do, then it would be more suspect for a judge to talk about the credibility than in a context where that's part of their role as the fact finder.
Another insufficient ground that we talk about here, Bill, is that, or, what I guess you have to get over this hurdle, that you have to show that the comment indicates bias or prejudice. So the mere fact that that the judge makes a comment that might disparage a party or is derogatory may not be enough. Is that the takeaway?
I think that's fair. And so if, for example, a judge has made a similar comment about both parties, then that would be some good indication that it doesn't show prejudice or bias because he's treating both sides equally. If he complains that the plaintiff seems to be overly litigious and the defendant seems to be overly litigious, well, that may be an indication that it's not based on prejudice or bias.
And Bill, one little quirk is 2330F. Lots of substitute counsel these days. How's that rule been interpreted?
Basically, the rule is set up so that after the fact or in the midst of a case, if you're not happy with what the judge is doing, but you don't have a basis for disqualification, well, I'll go hire a former partner of the judge, go hire somebody the judge doesn't hear cases from for some reason. And now all of a sudden you've got a basis to get rid of that judge. And this rule is set up to avoid that kind of game playing by saying you can't bring somebody in as additional counsel or substitute counsel if the result of that is to create a basis for disqualification that didn't previously exist.
How far do you think this goes, Bill? I can remember every day in court where a defendant's attorney would have someone show up as stand-in counsel, maybe because it was just a quick motion calendar just to reset something. What if something happens between the judge and that stand-in counsel?
If that stand-in counsel is not going to be further involved in the case, then it seems to me it would only come up if you could show that what occurred in that hearing involving the stand-up counsel created some bias or prejudice. So the fact that they're not going to show up later doesn't change the fact that maybe the judge was biased against them, which resulted in an adverse ruling in the case in which they were appearing as counsel.
And then finally, on insufficient grounds, adverse rulings. Bill, how often does this come up? I've seen many cases where the grounds for seeking disqualification is because the party got a bad ruling. How often did this come up for you?
This is clearly the biggie. A party isn't happy with how a judge has ruled on a given case, and they think the ruling not only is erroneous, but it is so erroneous that it in and of itself shows some bias or prejudice. And the general proposition is that an adverse ruling is never a sufficient basis for disqualification because partially because you have another remedy. At the end of the case, you can appeal those rulings by the judge, and if they were indeed erroneous, the appellate court can make a correction to it.
Now we're going to turn to the determinations by the judge. Here we have the determination for the initial motion. Bill, what are the outlines of 2330H?
The key here is that a judge is not allowed to pass on the truth of the facts that are alleged. If a party files a motion that says the judge said XYZ to me off the record that shows prejudice, the judge is not allowed to respond and said, no, I never said that. They have to take the facts as alleged as true. So their only role is to determine whether the motion is legally sufficient, which means, does it meet the requirements such as, is there an affidavit, is there a certification of counsel, etc.? And are the facts alleged, which you now have to assume are true, are sufficient for disqualification? So, for example, if the facts that are alleged are that the judge made this erroneous ruling, since that's not a sufficient basis for disqualification, even if you assume those allegations are true, it now would not be sufficient for disqualification. But any facts that are set forth in the motion, trial judge has to take as true and then say, okay, if the motion is legally sufficient, are these allegations, if true, sufficient to show bias or prejudice? And if so, he or she has to disqualify themselves, not saying they even did those things that are in the facts, but they've got to take them as true for that purpose.
With respect to legal sufficiency, we've highlighted very important words. There's an objective standard here. Bill, how have the courts interpreted well-founded fear? What's enough?
I think it's very fact specific on a case-by-case basis, and you just use a common sense sort of analysis, which says, let's look at what they've alleged. Let's assume it's true. If that's indeed true, would a reasonably prudent person think there's bias? And in most cases, they're not that close to the line. They either are or aren't sufficient. I don't think in most cases you end up real close to the line. It's just fairly obvious from common sense that it either is enough or it's not enough.
Got it. And of course, as you touched on, the trial court must accept the facts alleged as true. What's the problem with looking beyond the facts, Bill?
It goes against what the law requires for purposes of disqualification. You don't want to allow a judge who's being alleged to be biased and prejudiced to be making the decision whether or not the facts that are being alleged against him or her are in fact true. For purposes of at least an initial judge's motion, the policy is we're going to take it as true, and if it's legally sufficient, then that's a proper basis for disqualification.
The general rule is that the court should not take issue with the facts, as you've been talking about, but there's this strange exception for the status of the record. Can you flesh that out for us, Bill?
Well, the status of the record is a pretty cut and dried factual statement that can be made. And so setting forth some statements about the context of the motions referring to a transcript is, if it doesn't go to the extent where it's really disputing the factual allegations that are being made against the judge, I think it's something that's almost, you might say, administrative. It's sort of cut and dried, and it doesn't go to the heart of the complaint. Then it may be okay. But it's sort of up in the air, and as you can see here, there's a question certified that's pending to really get to what the parameters of that exception are.
Yeah, and we've included this case here, Manuel via State of Manuel, which was decided just recently by the 4th TCA. They have a really good discussion about what this exception is, and they've certified the question to the Supreme Court. Next, we're going to talk about what happens while the motion is pending and why what happens is important. So generally, Bill, what has to happen once the motion is filed?
Once the motion is filed, the judge is not permitted to do virtually anything else unless and until they decide the motion. The idea being, once the allegation of prejudice has been raised, you don't want the judge doing substantive things before that motion is resolved. There is an exception that if the judge has already issued a oral ruling and they prepare a written order to reflect what the oral ruling was, that they can do. That's basically a ministerial duty, and they're allowed to do that. It would have to be a definitive ruling being reduced to writing. So if the judge has given a strong indication which way he or she is leaning, but hasn't made a definitive ruling, then I think they could not enter an order along the lines of the way they were leaning, because they hadn't made a definitive oral pronouncement of the ruling prior to that time.
Yeah, and the Berry v. Berry case spells it out really clearly. Obviously, if all the judge is doing is memorializing what he or she has already said, then there's no exercise of discretion in doing that,
Exactly.
which is the exact point of the ministerial duty exception. A little bit more on when ruling. The motion that is untimely and lacks a certification by counsel is legally insufficient. But if the trial judge comments on the truthfulness of the facts, what happens?
This is an interesting case we've set forth here, because the trial judge certainly has a right to determine that a motion is untimely. And if he or she makes that decision and denies the motion on that basis and it ends it right there, then there's no disqualification. In this case, the judge, having determined it was untimely, then went on to make comments about the truthfulness of the facts, which is beyond what a trial judge is supposed to do when looking at one of those motions. And the court held in that case that sort of trumped the untimeliness, because the court went further than it should have in just deciding the untimeliness, and decided in that case that created a new basis for disqualification, didn't require a new motion to be filed in that regard, and granted the original motion, which otherwise would have been denied simply as untimely.
What about reconsideration, Bill? Can a party ask the successor judge to reconsider?
The parties can certainly ask the successor judge to reconsider any factual or legal rulings. This provides that the motion for consideration be filed within 30 days of the order of disqualification. That's so that if you have a prior ruling that you think is somehow tainted by your alleged allegations of bias, this gives the court an opportunity to address that and correct that.
Great. And now I want to bring Tom in for a discussion about successive motions, and then we're going to talk briefly about appellate review. Tom, you there?
I am here. Thank you, Robert.
Of course.
And thank you, Bill, for that excellent presentation.
So, Tom, if a judge is disqualified, can you flesh out what the standard for disqualification would be for a successor judge?
Yes, that's a great question. Because as Bill explained, for the initial motion for disqualification, the judge must accept the factual allegations as true. But that's the big difference between a second motion for disqualification directed at a successor judge. That successor judge is not required to accept the factual allegations and may actually rule on the truth of the facts alleged in support of the motion. The obvious purpose of this change in standard is to prevent a party from simply shopping until they get a judge they like by making perhaps outlandish accusations. And one other thing I'd like to add about that is there's a difference between a motion for disqualification directed to the successor judge versus a second motion for disqualification directed to the original judge that was perhaps denied. Any successive motions for disqualification directed to the original judge are handled under the original standard, which is that the judge must accept those allegations as true.
Yeah, and this is a case that talks about the, or at least explains why this is problematic if it were just to be legally sufficient for the second motion as well. Talk a little bit about, Tom, talk a little bit about legal sufficiency versus partiality in fact.
Well, that's really getting to the difference in the two standards. Legal sufficiency, again, means that the initial judge simply looks at the facts alleged and decides whether they would be sufficient for a reasonable person to feel they could not receive a fair or impartial trial. But again, once we've moved on to a successor judge, once a motion for disqualification has been granted in a case, that is no longer enough to get disqualification. Actually, you must prove, if you want to have the successor judge disqualified, you must prove that to that judge that they are partial or biased in fact, not just as alleged.
Got it. Well, let's talk for a few minutes about appellate review. How would a litigant seek review of a motion denying disqualification?
Yes, thank you. Thank you, Robert. That's a great question as well. If you file a motion for disqualification, either to the original judge or to a successor judge, perhaps, and it's denied, what are your options? How can you seek review of that order? And the answer is in something called a petition for writ of prohibition that would be directed to the appellate court. And a writ of prohibition is simply an action in the appellate court to challenge that a public official, in this case, that would be the trial judge, to challenge the jurisdiction of that public official to act in a case. And that fits perfectly with the disqualification, because the entire point of the motion is that the judge shouldn't be acting on the case because of their bias. So prohibition, there is no actual specific time limit to file a writ of prohibition, although the case law indicates that the writ should be filed within a reasonable time. And failure to file the writ within a reasonable time, whatever that would be in the case, probably within 30 days, but it could even be sooner, perhaps, based on the circumstances, is grounds for the appellate court to deny that writ of prohibition. And it's also important, corresponding to the different standards applied to a motion to disqualify the initial judge and a motion to disqualify the successor judge, the standard of review on appeal or on the writ of prohibition is different for those two rulings. For the initial motion, the appellate standard of review is de novo, which means it's simply a question of law, and the appellate court doesn't give any deference to the decision of the trial judge in ruling on the legal sufficiency or timeliness of the motion. Where you have a motion for disqualification directed to a successor judge, however, a writ of prohibition, the standard of review by the appellate court is abuse of discretion. And that makes sense because the successor judge is actually going to look at the evidence and decide whether, as a matter of fact, that he or she is biased and cannot provide a fair trial to the parties. So that motion would be reviewed by abuse of discretion.
And this next slide kind of dovetails with that, Tom. As you said, the appellate court now is going to look at the record. What's the standard for reversing?
Well, again, it's the Pinfield case that's cited in the slide talks about whether the record clearly refutes the successor judge's decision to deny the motion, which really is perhaps the converse of the appellate standard of review of abuse of discretion, because the judge is given wide latitude based on the evidence to look at all the evidence and decide whether or not, in the context of that case, that evidence was sufficient to establish a valid basis for disqualification. So because that judge has that discretion, that's why it's not reviewed de novo, but by that appellate standard of abuse of discretion.
Mm-hmm. So it's really doubly difficult on the second motion because you've got the trial judge who's actually looking at the facts. And then, as you pointed out, it's not de novo review, it's abuse of discretion. So it's doubly difficult for the party to succeed.
That's entirely correct, and that's no accident. The reason for these different standards, depending on whether it's an initial motion or a motion directed to a successor judge, is, as we discussed, the main policy is to prevent judge shopping, to make it difficult for a litigant or an attorney who just doesn't like a judge who would prefer a different judge to simply make any allegation that they want and to get their way. Obviously, the court system can't function very well with that going on, and because of that, these different standards have been set forth.
Shannon, I know you wanted to make a comment about the appellate part of this presentation.
Well, thanks, Robert. I was just thinking about the sort of the tough position that trial lawyers are in because they are facing these trial judges in their everyday work. And so sometimes, it's awkward for them to be placed in a position of feeling that they're ethically need to file a motion to disqualify the trial judge. And then also if the trial judge denies that motion, then now they're running up to the appellate court to file a petition for writ of prohibition. So I was just thinking about how our firm and other appellate firms handle petitions for writ of prohibition on somewhat of a regular basis, just because of that awkwardness that the trial lawyers are placed in.
Great. I know we have a little bit of time left for questions. Shannon, do you have any questions from the chat?
I don't have any questions from the chat at this moment, but I'm open to questions if you can think of some, Robert.
Yeah, we have a few. Let me see what we can squeeze a few in here. So there was one question, maybe Bill, you could address this, or I think you did, about the campaign contributions that they are generally considered de minimis, correct?
Yes, I think that's a good judge of one of the ways to determine whether something is de minimis or not for purposes of disqualification, that there is some established law out there in the campaign contribution that shows a contribution is de minimis if it's within certain limits. And that's just a good basis of comparison for other analysis as well.
Okay. We have another question. Can the judge commenting on the credibility of an attorney, whether good or bad, be a basis for disqualification?
I think it could be, because I think it could meet the standard of showing bias or prejudice. And if the court is biased or prejudiced against an attorney, it can have detrimental effects on the parties, such that they're harmed by that bias. And therefore, I think that could indeed form the basis. Once again, if it's based on something other than maybe the judge commenting on something that he has specifically seen before him in the context of a hearing.
And I have another question from someone else, but it's a good follow-up here. So let's assume that the judge disqualifies him or herself because of some sort of interaction that happened in a particular case between the lawyer and the judge. But then that same judge is also assigned or gets assigned to that lawyer's other cases. Is it going to be a case-by-case disqualification, or does the fact that the judge disqualified in one case means he or she should disqualify in all cases with that lawyer?
I think you'd have to look at the specifics of the basis of the disqualification. If the basis of the disqualification in the first case is some interaction with the lawyer makes this judge say they can't fairly judge anything that lawyer says, then that seems to me to be broad enough that it would hold over to other cases. If somehow the comment was specific to a certain case or a certain type of case, he makes some comment, he's going to disqualify himself with this lawyer because of something related to their personal injury practice or something. Maybe it wouldn't hold over into some other area. So I think it would have to be pretty case by case basis.
All right. And I'm looking through the chat here just to see what other questions we might have. Bear with me.
While you're doing that, let me point out one thing just to make it very clear. When we talk about successive motions and the different standard, that requires that it be a successive judge. The rules are set up that if a first motion is successful and now you get a second judge, it's a higher standard. That doesn't apply to a second motion before the first judge if the first judge has denied the original motion. So successive motion in this context means successive motion before a successive judge, not simply a successive motion.
That's a really good point, Bill. Thanks for bringing that up. Well, I don't see any other questions in the chat at this point. Obviously, if anyone has questions, as Shannon mentioned, you can contact us, go to our website and email any one of us, or go to info@floridaappeals.com and send your email there. Here is the course number and the number of credits you get for this particular CLE. And Shannon, I'll turn it back over to you.
All right. Thank you, Robert. And thanks so much, Bill and Tom, for that excellent analysis. And once again, the course does qualify for 1 hour of general credit and 1 hour of appellate certification credit. And the number, just so we can say it out loud for those that may not be able to view their screen, is 2307398N. Thank you for joining us.